Time now is 1:17. We're back on the record.
Mr. Ewers, have you ever had any involvement with the Point of Arguello deal?
No, sir.
Are you familiar with that Point Arguello deal at all?
Only through Ben Lassiter.
Only through what?
Ben Lassiter,
Who is that?
business associate of mine.
Okay, how would you know about Point Arguello through him?
Well, he told me that they were trying to purchase this Point of Girl.
They were trying to what?
Purchase it. It was an oil and gas project.
And who is they in that sentence? You said that he said that they were. Who is they?
Ben Lassiter, Treasury Oil, Gort Collier, Gort Collier, Ron Organ, Irvin Birnbaum.
Mark that, please. That.
Are these stapled?
Yeah, they should go together. And that, and I don't care about the order. So if you get them mixed up, don't worry about it. I've only got a couple of questions on each, so don't get too concerned. Good thing I don't care about the order because I got them out of order.
These originals back to the court reporter so they don't get
Okay.
messed up.
Get them marked the way you wanted them, or?
Yeah, one of these days, no one could find one of the exhibits. And no one had left.
Really?
Weird.
I've had before where I wanted to
Yeah, me too.
ditch them.
In order from bottom to top, you know,
Okay.
Check 'em real quick.
It doesn't make any difference. Just your copies.
Okay.
Unfortunately, they're all mixed up. It's all right. That's a little trick I pulled. Okay. I'm going to start with Exhibit 6. Could you identify that for us, please, Mr. Ewers?
This is a it appears to be a interest calculation sheet that was prepared by Buckley Matthews.
Okay, and that was my question. That's your signature on the top of it? Is that your handwriting?
Yes, sir.
And it says Mr. Pladot, that's to Alex Pladot, correct?
Yes, sir.
And it says the other group prepared this for me. The other group is Buckley Matthews?
Yes, sir.
All right. I want to hand you what has been marked Exhibit 7. Can you tell me what that is?
A memorandum of understanding between myself, Mr. Band, Mr. Playdot for the two trusts that he represented.
Okay, at this point in time, you would have known that Buckley Matthews and ICF owned part of the program, correct?
Yes, sir.
Did you inform ICF that you were entering into this agreement?
Which agreement are you referring to?
I'm talking
sir?
about the exhibit I just handed you.
The
The
memorandum.
memorandum of understanding, right?
Did I inform ICF?
Yes.
No, sir.
Did you inform Larry Ewers? I mean, I'm sorry, I guess
Yes,
you did.
sir. I did inform Larry Ewers.
Howard, I mean, was it Eugene Liner? Is that his name? Yeah, Eugene Liner.
Yes, sir.
You did tell him?
Yes, sir.
And did you tell him orally?
No, sir. I sent him a copy of it.
All right. And have you seen a cover letter forwarding that to him?
Mr. Green, I don't remember. We had a phone conversation about this, and so I don't think I sent a cover sheet.
I want to hand you Exhibit 8. Could you tell us what that is?
Oh, absolutely. And this is an agreement that was signed between Mr. Playdot and myself.
All right. Did you inform Mr. Liner about that agreement?
I don't know if I informed Mr. Liner, if I informed Buckley Matthews about it. I believe, I know I informed Buckley Matthews, but I can't attest to if I personally informed Mr. Liner.
And this agreement is dated May 5th, 2003, correct?
The last one you just gave me, sir, was the 29th day of January.
Am I looking at the wrong one? Can I see it back? I'm sorry. Yeah, that's not the one I'm looking for. Okay. That's all the questions I have about that one. I'm sorry. I want to hand you Exhibit 9. That one's dated May 5th, 2003, correct?
Yes, sir.
Looking at that exhibit, and that's an exhibit that you signed, correct?
Yes, sir.
And you're actually entering into an agreement with Alex Pladot, correct?
Yes, sir.
You're giving your word and promise to do something. He's giving his word and promise to do something. Correct? I mean, that's what an agreement is, isn't it?
Yes, sir.
Looking at the first page under agreement, talks about monies and deposits. Monies recovered which may belong to Mr. Herron, frozen in a bank account pending final determination by order of the court of competent jurisdiction or qualified legal opinion authorizes they belong to Mr. Herron and may be applied against the debts owed by Mr. Herron, which Mr. Herron will be dispersed in accordance to item 2 of this agreement. What funds were frozen?
This again was part of the Feldman scam that we was misleading Mr. Pladot.
So the scheme to lie to Mr. Pladot went so far as entering into an agreement with him that recited lies?
Yes, sir.
When did Mr. Feldman cease being your lawyer or being your lawyer on this deal?
Probably early, probably sometime in 2003. I don't have the exact date.
Mm-hmm. But in here, you were representing a lie to Mr. Pladot when you were suggesting that there is money of Mr. Herron's frozen in a bank account.
Form.
Correct?
Yes, sir.
Form.
Pardon?
Same objection.
Yes, sir.
Down here, when you say 71.49% to the Ewers group, who is the Ewers group?
Yours group would be all of the parties who had a interest in the Herron transaction.
Which would be Liner, ICF, Buckley Matthews,
Yes, sir.
and yourself.
Yes, sir.
Anyone else?
No, sir.
Did you inform Liner, ICF, or Buckley Matthews that you were entering into this false agreement?
I don't-
Form, and I'm going to instruct the witness not to answer that because any answer could be misleading.
Is this a false agreement?
Objection, and I'm going to instruct the witness not to answer that.
It says here frozen in a bank account. That's a lie. We established that, correct?
Mr. Green, do you want me to clarify my
No.
instruction? Okay.
No.
Same
That's a lie,
instruction.
isn't it?
You can, could you restate the question?
The statement frozen in a bank account pending final determination is a lie, correct?
I object to the form of the question.
Is that a lie? He's not. He's not instructing you not to answer it, is my understanding. He's objecting to the form of the question.
Yes, sir.
Did you inform ICF, Liner, or Buckley Matthews that you were entering into this agreement?
I do not recall.
Did you inform them of this scheme to lie to Mr. Pladot?
Objection form.
Buckley Matthews and Liner was aware of it. Yes, sir.
But ICF was not?
I can't say what ICF knew or didn't know.
You didn't tell them?
No, sir.
I want to hand you, and we're getting out of order, but this is the order it's here, but it's Exhibit 26, probably in the order that I gave it to you, though.
Okay.
Let me know when you're ready.
Yes, sir.
Who's Bill Lamb?
Mr. Lamb was an attorney in North Carolina.
And, go ahead, I'm sorry.
I'm sorry, sir, if I interrupted you.
Read through.
I don't know what you want me to answer on Mr. Lamb if I've answered your question.
What was your involvement with Mr. Lamb?
I had no involvement with Mr. Lamb other than contacting him on several occasions if he had any information reference to Christopher Heron.
Where'd you get his name?
From documents that we had seen that were Mr. Lamb had attempted to do a transaction with Mr. Heron.
It says, I was introduced to Bill Lamb, and this email is from you, is it not?
It indicates it is, yes, sir.
Yeah. Do you remember sending this email?
No, sir, I don't.
Do you dispute whether or not you sent this email?
Without looking at my copy of it, I can't say if this is what I sent or didn't send.
Okay. It says here, I was introduced to Bill Lamb, but ended up C&D-ing him. That means cease and desist? Is that what that means?
Yes.
What were you ceasing and desisting?
Well, I didn't know that this was the same Bill Lamb until later on, but Mr. Cho had tried to do a deal with Mr. Lamb, and Mr. Lamb was calling, making threatening phone calls, and Mr. Cho asked me to send a C&D.
Okay. Next paragraph, the law firm we consulted with was Cleary, Gottlieb, Steen, and Hamilton. Do you know that law firm? I think we'd asked you about that before.
We're on a different one again.
Are we?
This is the one.
Oh, we are on different ones.
Like this one.
I apologize.
That's all right.
I thought I was. That's what I get for trying to think I'm organized.
This is the one. Copy.
Okay, let's do that one. Yeah, I'm sorry. 10.
Exhibit 10.
I'd asked you earlier about the law firm of Cleary, Gottlieb. Here you mentioned the firm here. Do you stand by the fact you say you don't know them, or?
I don't know of them personally. This was a name that Mr. Feldman and I came up with.
The next to last paragraph says, I will give you a call later to go over the above and secure your comments to be relayed to our attorneys. We will have a member of the firm in the office of the attorney who is handling the second jurisdiction on Friday. What does that mean? What
It's-
second jurisdiction?
Part of the misleading statements that was made to Mr. Playdot,
Part of the scheme to lie to Mr. Playdot,
part of Mr. Feldman's scheme.
but that you were participating in.
Yes, sir.
Mr. Feldman's not lying in this. You're lying in this.
Yes, sir.
Does that make a lie okay if somebody else tells you to do it?
I don't think so. I've already think I've addressed that it was wrong, Mr. Green.
What was the first jurisdiction?
The UK. You know, and I make note that this was an email, and then I make note that at the top, it shows that it was faxed. So I'm wondering if this document is authentic or not.
But you're not denying the document.
No, sir.
I need to add this as 21. Do you care if I put a 21? I just put the second page on it. Put the 21 on this one and put them together, please.
Put it on the front page.
Yes, please. Handing you, Mr. Ewer's Exhibit 21. Can you identify that for us?
Yes, sir.
In the second page, last paragraph, well, first of all, the bottom of the second page, that's your signature, is it not?
It appears to be, yes, sir.
So this is a letter that you sent to Mr. Playdot.
It appears.
In the last paragraph, you say, I have attempted at all times to keep you informed of all aspects of the U.S. and U.S. and Canada litigation. What litigation was there in the U.S.?
There was none.
So this was a lie.
Yes, sir.
And Canada litigation. What litigation was there in Canada?
As so previously stated, there was none.
All right, so that's a lie too.
Yes, sir.
Then it says, I have and will continue to seek and listen to Mr. Samuels for all legal advice. And you don't know who Mr. Samuels is?
Is a name that I picked out.
You just out of the blue?
Yes, sir.
Just made it up.
Yes, sir.
Didn't look for some name someplace and came up with it. You just made it up.
I can't even tell you today if there is a Mr. Samuels that works at the firm or not.
Okay. Well, did you have any involvement at all with that firm?
No, sir.
How did you pick that particular firm to make up?
Mr. Feldman told me it was one of the most respectable firms in the U.S.
So all of these references to Mr. Samuels here is a continuation of your lie to Mr. Playdot.
A continuation of the scam that Mr. Feldman got me to participate in. Yes, sir.
It was a continuation of your Larry Ewer's lie to Mr. Playdot.
I lied to Mr. Playdot, if that's what you're asking me.
Yes, that is what I'm asking you. I want to hand you what has been marked Exhibit 22.
Okay.
This is another email to Mr. Pladot from you, correct?
Yes, sir.
And here you say subject Canada, and that Mr. Samuel has studied all cases Bank House or Pomeroy have been involved in. That's a lie, is it not?
Yes, sir.
And who is Bank House or Pomeroy?
Corporation of the Bank House and Jim Pomeroy. Jim Pomeroy was CEO of Corporation of the Bank House. Corporation of the Bank House is an entity that Mr. Heron was using, and the address that was used in the Memorandum of Understanding was the address of Corporation of the Bank House in Boston, Massachusetts.
Right. Did you find any money from Bank House or Pomeroy?
No, sir.
And you don't know anybody who did?
No, sir. There are numerous suits filed against those two names, and accordingly to all of the ones that we contacted as the plaintiff, they found nothing.
I want to hand you Exhibit 23. This is a email from you to whom?
To Malcolm Harris.
And who is
was-
Malcolm Harris?
Malcolm Harris was the trustee in the UK for the Christopher Patrick Heron bankruptcy. And to Mr. Pladot.
All right. I just returned from New York and Boston meeting with attorney from looking at the possibility of additional actions against the U.S. in the U.S. to marshal and collect assets he may or may not have in the U.S. Is that a lie?
I don't believe the lie is on meeting with attorneys in Boston. No, sir.
Okay. Did you meet with the attorneys, or did you go to New York and Boston to meet with attorneys?
I went to Boston and New York to meet with attorneys, and I met with a partner of Edwards Angel in New York.
And that's Mr. Spiro's law firm?
Yes, sir. And the litigation that we refer to is the litigation that was eventually filed in Boston, Massachusetts.
Here's a statement that the answers to the above were not needed at the time of the filing. The two other proceedings, due to filing prior to Mr. Heron's bankruptcy. What other two proceedings?
There was none.
So that was a lie?
Yes, sir.
So you're lying not only to Mr. Pladot, you're also lying to the trustee in bankruptcy in the UK.
Yes, sir.
What is your justification for lying to the trustee in bankruptcy in the UK?
Taking poor advice from legal counsel.
No, non-responsive. For what reason would you have to? You've told us that you lied to Pladot to get him to quit calling people. What reason did you have to lie to the bankruptcy trustee?
Objection form.
Same answer, sir.
To get the bankruptcy trustee to quit calling people?
Objection form.
No, sir.
Okay.
I
So what were
took the advice of my legal counsel.
your legal counsel told you to lie to the bankruptcy trustee,
Yes, sir.
and you thought that was okay?
Looking back, no, sir. It
I'm
wasn't okay.
talking about the moment you told the lie. Did you think it was okay to lie to the trustee in bankruptcy?
I don't know, sir. You're asking me something that was 5 years ago. I don't know exactly what my thought process was at the time.
Well, we know you lied to him, correct?
Correct.
And you can't tell us whether or not you thought that was okay when you were lying to him?
I did it based upon a recommendation of my legal counsel.
I understand you did it based upon because Johnny told you to, okay?
His name's not Johnny, sir. His name's Anthony Feldman.
Okay, I realize that you're saying you lied because somebody told you to lie. My question to you, didn't you know that that was wrong when you were doing it?
Objection form.
I'm sure that I was uncomfortable in doing it.
I
Yes,
don't
sir.
mean uncomfortable. Don't you know didn't you know at the time that it was wrong for you to lie to the trustee in bankruptcy?
I'm going to stick with my answer, sir.
You haven't answered my question. My
I've
question
answered
is,
it
No,
that
did
I
you?
knew that I was uncomfortable with it.
I'm not at, my question doesn't go to whether or not you were comfortable. My question is right and wrong. Won't you admit
The day
to this-
it was
Let me finish my
wrong.
question. Won't you admit to this jury that at the time you lied to this bankruptcy trustee, you knew it was wrong to tell a lie to this bankruptcy trustee?
Form.
I'm sure I knew.
Okay. But you did it anyway. Correct?
Yes, sir.
I'm going to hand you exhibit number 24.
Okay, sir.
This is the email from you to Nicholas Pike. Who is that?
Nicholas Pike was an attorney that replaced a law firm in London, and he was representing the trustee in the bankruptcy of Christopher Patrick Heron.
All right. First sentence, there are litigations ongoing. Second sentence, one, you offered a legal opinion along with the others filed prior to a bankruptcy petition against Heron in the UK. What other litigation was filed prior to the bankruptcy petition against Heron in the UK?
The litigations that I was referring to was the litigations that was either had been filed or were going to be filed in Boston, Massachusetts.
Well, it said filed prior to the filing of the bankruptcy. The Boston litigation was not filed prior to the filing of the bankruptcy, was it, sir?
No, sir, it was not.
So this is a lie.
Yes, sir, based upon that.
Okay. So now, this message, this original message here, was not even to Mr. Ewers, was it? I mean, Mr. Pladot.
No, sir.
And so you're lying to Mr. Pike, who is representing the trustee, and you're copying the trustee.
I believe that what I was referring to here, sir, was litigations that had been filed against Corporation of the Bank House, Jim Pomeroy, and others.
That's not my question to you. We've established that you were telling a lie in this first sentence. My question to you is, that lie was being told to Nicholas Pike, the attorney for the trustee and the trustee, correct?
Objection form, and I instruct the witness not to answer the question on the basis that any answer would be misleading based on his testimony.
Okay. Can I see the exhibit before this, please?
This one?
Yes, I think it's that one. the first, second, third, fourth, fifth, sixth, seventh paragraph down, at no time have we failed to be forthright with the trustee. That is a lie, is it not?
Objection form.
We've already established that you told them a lie on December 11th, 2003 in Exhibit 23. So when you're telling you've always been forthright to the trustee, that is another lie, is it not?
I think there would be information that would show that I had clarified what was told to the trustee in the previous letter, which clarified that there was no lawsuits filed.
So you think you've got some documentation that says, hey, what I told you in Exhibit 23 wasn't true. I've got this scheme to lie against Ladot.
I don't know if I have the documentation or if this was written or was in a telephone conversation with Mr. Harris.
Okay, what we have established is that you lied to Mr. Malcolm in Exhibit 23. You told us that.
Yes, sir.
And then you're saying, and that was, the date of that was December 11, 2003. Then in January 14, 2004, you're saying, at no time have we failed to be forthright with the trustee. That is incorrect, isn't it? Because you lied to him on Exhibit 23.
Form.
Based upon looking at these two documents, you are correct. Based upon what I told to the trustee, I had clarified the first email that you're referring to.
But you, at least at one time, you hadn't been can't even talk. Forthright with him. You had lied to him.
Correct.
Hand you Exhibit 11. That is a email from you to Mr. Pladot,
Correct.
and that you say next week in Toronto. Is that a lie?
Yes, sir.
And this lie was told by you to Mr. Pladot in 2004.
Yes, sir.
Was Mr. Feldman still a lawyer in this case in 2004?
No, sir.
So you're, without Mr. Feldman telling you to lie, you're continuing to lie to Mr. Pladot.
Continued the Feldman scheme. Yes, sir.
Was Feldman, Mr. Feldman replaced by anyone?
Garcia Martin for a short period of time, and then another firm.
What was the other firm?
I don't remember. I've just gone blank on the other firm, sir.
Did you talk to these other firms about this scheme to lie to Mr. Pladot?
I informed the attorney that I had been asked to do these things. Yes, sir.
And what did they say? Go ahead.
No, sir. He didn't offer a comment.
And what is the name of the lawyer who didn't offer a comment?
Sir, as I've just stated, I've gone blank
Okay.
with the law firm. I'm sure you have the records of
But it was the law firm that replaced Mr. Feldman.
Replaced Garcia Martin. Garcia Martin replaced Mr. Feldman when he was struck off the roll.
Did you talk to Garcia Martin about this scheme to lie to Mr. Pladot?
No, sir.
I'm going to hand you exhibit number 13.
I'm through.
Okay. This is another email from you to Mr. Pladot, correct?
Yes, sir.
Second paragraph, the hearing was to obtain an order to move the funds into a trustee account. What funds?
There was no funds. This is another continuation.
Continuation of the lie?
Yes, sir. And a lot of the reason why this continues, sir, is because we thought our computer was compromised. And Mr. Once more, the facial expression of the defendant. We were concerned that my computer was compromised, and Mr. Pladot was fully aware at this time what was going on.
Responsive. Are you telling us he knew you were lying to him?
Yes, sir.
And he didn't call you on it? He didn't call you on
Oh,
it?
we had discussions about it because it was very shortly after this that he wrote the letter to the trustee acknowledging that it was a Feldman concocted story.
Okay, so you talked to Mr. Pladot, and Mr. Pladot says, yeah, I know you're lying to me, but
No, I don't know exactly what Mr. Pladot said, but I informed him and that we decided to keep it going because we felt my computer was compromised.
and what made you feel your computer was compromised?
Just the information I was getting coming back to me, different sources.
Like what? Give me an example.
I don't remember what was being sold, but it seemed like people was always ahead of us in the people we were contacting, sir.
People you were contacting trying to find money seemed to be ahead
Yes,
of
sir.
you?
Yes, sir. And they were getting there before we were.
Who is they?
Other parties
Other people?
that we never got the name, sir. We was always told when we contacted them that they'd already been contacted.
Other parties trying to get Herring's money?
Yes, sir.
So is there any other reason to believe that your computer was compromised other than that?
No, sir.
So are you now telling us that Mr. Pladot is a part of the lie to Mr. Pladot?
I think his letter that he sent to the trustee, he says it. I don't say it. He says it.
That's not what my question is to you, and I object to the response to this. Are you telling us that Mr. Pladot was part of the scheme to lie to Mr. Pladot?
Mr. Pladot was aware of it, and because of the reasons that I've just stated about our fear that our computer was compromised, went along with it.
When do you think Mr. Pladot started going along with this lie to Mr. Pladot?
Sometime in mid to third of, somewhere in the third quarter of 2003.
Good time to change.
Yes.
Time's 2 minutes after 2, we're going off the record.
I want to take